You are listening to the Schoberg and Tibelius podcast, where our attorneys discuss key issues that affect the decisions you make in regard to your business, your family, and your estate. Each episode will provide important information from highly skilled legal professionals who are dedicated to helping you achieve your business and personal goals. Please know this podcast does not create an attorney-client relationship between Schoberg and Tibelius and its attorneys with the viewer-listener. The information provided herein is general and is not to be interpreted as legal advice in regard to any unique case or issue.
Mediation. If you are anticipating a divorce or paternity matter, you will be asked to consider mediation. It's simply a process to reach an agreement. It's not complicated, it's really not difficult, and certainly it's not life or death. But it has become the best friend of all judges and referees. They encourage mediation for good reason, early and often. This brief talk is about why we mediate. In the next one, we'll talk about how to do it well. There are 3 good reasons to mediate. The first and most important is you get the best outcome. Think about this with me. Who knows you and your case better than the 2 of you? Who better to make decisions for you than you? Who knows the kids' needs, the budget, the assets? You do. Now, I know the obvious pushback here is, well, if we could communicate and make good decisions together, we wouldn't be getting a divorce. Well, okay, fair comment. But you're contemplating mediation because you've decided to part ways. And everyone who's decided to part ways needs to deal with making decisions. They must put aside the anger or resentment or the hurt feelings and begin to make good business decisions. A decision to divorce creates the need to make decisions together. That's just the new reality. Second reason mediation makes sense. You retain control. If you refuse to mediate or mediate poorly, you force the judge to make all of the decisions. Now, I've come to anticipate that judges and referees will make good decisions in most circumstances when called upon. But you can make the best decisions for you and your family. You can tailor the decision to your exact and unique circumstances. You can be more creative. One positive side effect of a stipulated versus litigated decision is you will have a lesser need to return to court in the future. You can more easily plan ahead for known changes. And that's huge. The third and final reason that mediation makes sense is the costs are less. Divorce resolved by a stipulation costs far less than one litigated. Certainly, less is paid to attorneys and to experts, but the real cost savings are time and anxiety. The court process in a divorce or paternity matter can drag on for over a year. I've had some cases that have gone 2 years. All the while, you are in a state of uncertainty. It is best to be done as quickly as you can, and mediating a resolution is vastly quicker than a litigated solution. One epilogue. While this blog is singing the praises of mediation to get a resolution in a family law matter, it is a bad option when one of the parties, is not willing to act in good faith. if one of you refuses to do the work to get to know the case, the kids, the income, the budgets, the assets, and all these things, that person will not be in a good position to make choices. And certainly, if one of you is cynical or evil, wanting to hurt the other, there's very little chance of success in mediation. But for the vast majority of people who are in this situation, mediation makes sense.
When you are searching for legal insight to guide life's important decisions, the highly trained attorneys at Schoberg and Tibelius are here to help. Call us at 651-738-3433 and follow us on our Facebook page at Schoberg Tibelius to get notified about our most recent podcast episodes. See you next time.